Hello, my name is John Smeaton, and on behalf of Voice of the Family, I welcome you to the Family and Life Academy and to the fourth lesson in our course on natural law. The course is written and presented by Dr. Joseph Shaw, a philosopher and author. From the origins of the natural law to the intellectual development of the Middle Ages and the Aristotelian revival in his first two lessons, in his last lesson, Dr. Shaw went on to cover St. Thomas Aquinas' synthesis of the Augustinian and Aristotelian traditions into the definitive formulation of natural law, also considering potential conflicts in rule-based ethics and the licity of material cooperation with evil. The first three lessons are available for you to watch again at whatever time suits you best on the Family and Life Academy website. For his fourth lesson, Dr. Shaw's subject is human law. At the end of the lesson, Dr. Shaw will answer any questions you may have about natural law, which you can put in the chat window. Without further ado, I will now hand over the stage to Dr. Shaw.
Thank you very much, Mr. Smeaton. In the last two lectures, I have set out Aquinas' conception of natural law. In the most recent lecture, I discussed the importance of rules, fundamental moral principles. Related to these, though distinct from them, are human laws, the laws established by custom, enacted by legislators, or determined by judges. The central question of this lecture will be, since natural law exists to guide human action, why is it necessary or useful to have human law as well? Human law is joined in Aquinas' list of types of law, additional to eternal law and natural law, by divine law. Divine law is the law which God promulgates as a divine legislator and which he can unmake. As already noted, it is particularly important for Christians to explain how and why various rules applied to the ancient Hebrews in the Old Testament, but do not apply to Christians today, including to Jews who become Christians. These include restrictions on what foods can be eaten and how to carry out divine worship. The answer is that a lot of these laws recorded in the books of the law, the first 5 books of the Old Testament, are like the laws of human states in that they are not eternal, but can be made and unmade. Other parts of the law of Moses are of more permanent significance. The prohibitions on killing and adultery, for example. The parallel with human legislation still applies, however, as human lawgivers also prohibit things which are wrong, as we would say, by the natural law. They do this not in order to make them wrong, since they are wrong already, but to include them among the customs and laws of human societies, so we know how exactly they are understood, how they are to be investigated, and suspects tried and punished. In this way, even human laws forbidding what is already forbidden by natural law will involve a certain amount of variation in how exactly they are formulated and enforced. Other things found in the law of Moses and other things found in human legislation are related to the natural law in a more complex way. These are things in the law of Moses which could be completely repealed by a divine decision, as when St. Peter had his vision of the unclean animals and was told to kill and eat them. That's in Acts 11, verses 5 to 10. I am not going to say too much more about the divine law, since this is the subject of Father Thomas Crean's lectures, which will follow my own, although it does provide some interesting parallels to human law. My focus is going to be on how human law is related to natural law. In the treatise on law, Aquinas tells us that the purpose of human law is to make its subjects virtuous, particularly those for whom the moral training of the family had proved inadequate. And I quote from the Summa Theologica, Prima Secunda, question 95, article 1. It was necessary for such to be restrained from evil by force and fear, in order that at least they might desist from evil doing and leave others in peace, and that they might be brought to do willingly what hitherto they did from fear, and thus become virtuous. Now, this kind of training, which compels through fear of punishment, is the discipline of the laws. Unquote. These quotations are included in my supplementary documentation available to students. Modern political theorists tend not to talk about the role of law in fostering virtue, but of course the suppression of crime and coercively habituating criminals into an honest life is very much what the criminal justice system is about. Aquinas' way of expressing this point reflects a long tradition. The care of the soul, as Plato called it, is inseparable from the goal of making the state's inhabitants happy, since happiness requires virtue. Law and order, which is a necessary condition of worldly contentment, also depends on the goodness of the community's members. Aristotle said that the purpose of the state, he refers to the Greek polis, the city-state, was to foster happiness, the ideal life. Modern political theorists tend to say that the role of the state is to create a space of public peace where people can choose what conception of the good life to seek. This is called state neutrality, that is to say, neutrality between conceptions of the good. In practice, the state in liberal democracies today has largely abandoned this ideal, and through the education of children, public information campaigns, and through the operation of many laws, quite explicitly aims to change attitudes. That's a phrase which is quite a favourite with them, not just in relation to crime, but in relation to a detailed, if not necessarily thought through, conception of virtue. This would include being anti-racist, progressive on social and family issues, and concerned about global warming. Part of the reason for this development is that it is impossible for a state to be neutral between conceptions of the good. The idea of neutrality seemed attractive in the post-war period, when there seemed to be a consensus about what conceptions of the good are worthy of consideration and which are simply unreasonable. State support for classical Western culture by paying for art galleries and opera houses, for example, was unchallenged. State recognition of Satanism as a religion worthy of charitable status was unthinkable. Now that the first is highly contested and the second has actually happened, at least in the United States, it has become clear that the state can hardly do anything without making a value judgment about what is a reasonable conception of the good and what should be discouraged, and these value judgments are often controversial. If we accept this, it does not necessarily follow that we are condemned to totalitarianism. There is a big difference between a state which disincentivizes drug addiction and insists on keeping Shakespeare in the national curriculum, as the British state currently does, and one which uses the firing squad and the gulag to try to effect a complete change in the entire population's worldview, as the totalitarians of the 20th century did. This is not the difference between neutrality and non-neutrality, but the difference between seeking moderate and reasonable goals using moderate and reasonable means, and seeking radical and unreasonable goals using radical and unreasonable means. The question of moderation relates to how close a goal is to current reality. The question of reasonableness is a value judgment. Something Aquinas could have taught Pol Pot is that if you think that the general population is radically unjust, it may be counterproductive to try to put them right too quickly, and some evils may just have to be tolerated in order to avoid greater ones. An oft-cited example of this is prostitution. St. Augustine notes in a work called De Ordine that God tolerates evils, presumably for good reasons, and so should a well-ordered state. Just as the public executioner might seem a person society should be without, but actually performs a necessary social function, so too with prostitution. Augustine wrote, and I quote, "Remove prostitutes from human affairs, and you will unsettle everything because of lusts." This last phrase has been translated in different ways in different translations, but the Latin is turba veris omnia libidinibus. There's a longer quotation containing this, giving a little bit more context in the notes. Augustine's example is troubling, since it suggests that the reason for tolerating prostitution is not that it would be impossible to suppress it, or that the cost would exceed the benefit, but that it serves as a kind of safety valve for disordered desires, an idea one would associate more with Freud than with a Christian tradition. Surely the availability of prostitutes undermines rather than reinforces the bonds of marriage and the continence proper to the unmarried state. That, of course, is an empirical question, at least in principle. The acceptance of this example, which is cited by Aquinas in his own discussion of toleration, explains the long history of the licensing of brothels in Catholic countries. The other applications are also important, however, and Aquinas' reference is actually in the context of a discussion about religious toleration. And I have in mind the place where he quotes this remark of Augustine's in the Summa Theologica Secunda Secundae, question 10, article 11. In general, the toleration of heretics and pagans may be necessary because it is simply impractical to do anything else. As Aquinas puts it, the reason for toleration may be simply that the heretics and pagans are too numerous. Toleration for this motive was practiced when Sicily and parts of Spain were newly reconquered by Christians from the Muslims, and the same principles later applied to the toleration of Protestants in France under the Edict of Nantes in 1598, which brought France's wars of religion to an end. As time gradually shifts the demographic balance, of course, policies can be adjusted. Aquinas' discussion focuses, however, on the toleration of the Jewish religion, to which other considerations apply. The treatment of the Jews in Catholic states is a matter of some sensitivity, so it is worth taking a moment to consider Aquinas' position. Not all religious minorities are the same, according to him. Some, like Hindus and the pagans of ancient times, worship idols, or at least appear to do so. Muslims, of course, do not. By their baptism, heretics are under the jurisdiction of the Church. Non-Christians and second-generation Protestants are not. All these factors make a difference in how they can be handled legally in the Catholic tradition. Jewish rites, Aquinas tells us, R-I-T-E-S that is, are derivative from, if not identical with, the religious rites established by divine law in the Old Testament. This makes these rites in themselves, as Aquinas puts it, truthful. In addition, Christians profit, that's the word he uses, by the continuing existence of the Jewish community with its religious traditions, because their rites foreshadow the truths of Christianity. When Christians point out that their claims are supported by texts composed centuries before the birth of Christ, others might doubt this, but the Jewish community and the copies of the Old Testament, which they preserve, bear witness to this tradition. Their testimony is all the more powerful, in fact, inasmuch as that they are opposed to Christianity. As Aquinas summarizes, and I quote, "Our very enemies bear witness to our faith," unquote. This argument comes directly from St. Augustine and St. Bernard Clairvaux, who is sometimes called the last of the fathers. And This view was the basis of a policy of toleration exemplified by Pope Gregory the Great and Pope Calixtus II, among many others. Aquinas quotes Pope Gregory insisting on tolerance for Jewish worship. In Aquinas' own day, this consensus was under attack in the context of what is known as the Talmud controversy. This controversy was ignited by the claim made by two Dominican friars who were themselves Jewish converts, that the Jews do not, after all, bear witness to the truth, since the Talmud introduces error into their religion. This controversy gave rise to the anti-Semitic violence, sometimes officially condoned, which marred the later Middle Ages. One of the difficulties was that Talmud, written in Hebrew, could be read by only a very small number of scholars in this period. The Talmud controversy was finally settled following the Council of Trent, when the Congregation of the Index, which was in charge of forbidden books, undertook a thorough examination of the text and rejected nearly all of the hostile claims made about it. Indeed, following this ruling, the Talmud could be printed in the Papal States, with some very small emendations. These are only a few highlights of the history of the Jews in the West in the Middle Ages, but it is worthwhile to underline the point that not only does the Catholic tradition not necessarily demand religious intolerance, but that its foremost spokesmen were forcefully opposed to both popular and official violence against the Jews. Another way in which Aquinas' view is moderate is that he acknowledges that not all virtues can be subject to human law. And he discusses this in the Summa Theologica Prima Secunda, question 96, articles 2 to 3. And this is for purely practical reasons. It is enough for human law to tackle the most important things, and above all, those virtues and vices which most directly affect the good of other members of the community. Generally speaking, Aquinas did not regard the internal aspect of virtue and vice as something which the state could try to influence directly. It is worth noting that in his day, the Church punished heresy, to be sure, but it was not thought crime which the heresy hunters looked out for, but the teaching of heresy, not an internal state of belief, but external actions which disturbed the peace of the community. This example raises an issue to be dealt with below of the different institutions, above all, the state and the church, which interact in the legal realm, and the relationship between our natural and supernatural ends as far as human law is concerned. The passage I referred to above is part of Aquinas' response to St. Isidore of Seville, who is quoted by Aquinas as defining human law in terms of the suppression of vice. This was a widespread view, and the view of St. Augustine. Aquinas' formulation is less negative. The role of human law is not just the suppression of vice, but the fostering of virtue. This is not just a difference of emphasis. Were a human society to exist where there was no vice, as in the Garden of Eden before the fall, Augustine did not think that political authority would be needed. Aquinas disagrees and thinks of Adam, the patriarch of the first human family, as exercising a form of political authority even before the fall, an authority which would have had more application, of course, if the community under his care had increased in numbers. Aquinas explains the exercise of authority of a free subject as consisting in, and I quote, directing him either towards his proper welfare or the common good. That's Prima Secunda, question 96, article 4. In the Garden of Eden, there would have been no need for people to be directed to their proper goods, that is, their individual benefit. But it might be necessary to direct people to the common good. Aquinas reminds us, and I quote, man is naturally a social being, so in the state of innocence he would have led a social life. Now, a social life cannot exist among a number of people unless under the presidency of one to look after the common good. For many as such seek many things, whereas one attends only to one. End quote. What is the common goal of social life in Eden? It cannot be peace, since there will surely be no war or crime in Eden. Each will freely give his neighbour what is his due. Instead, the goal of social life itself may require collective projects for the common good. These might include projects which benefit the whole community, such as building a bridge. But in a more general way, political authority has the role of fostering civic friendship, the cement and crown of the political community. The development from Augustine and Isidore to Aquinas is important as it gives the state a wider and more complex role in society. Given the purpose of human law, the next question is how a human legislator can enforce, change, or add to the obligations of natural law. In two famous passages of the Treatise on Law, in the Summa Theologica, Aquinas sets out the foundations for his philosophy of human law. First, he asks whether natural law can be changed. His answer is that it can be added to, but nothing can be taken away from it, at least from its first principles. In explanation for why things might be added, he says, and I quote, "Many things for the benefit of human life have been added over and above the natural law, both by the divine law and by human law," unquote. That's from the Prima Secunda, question 94, article 6. The human legislator must bear in mind that he cannot attempt to subtract from the natural law by commanding someone to act against it. Second, Aquinas makes a distinction between two different ways in which the human law might be derived from natural law, as a conclusion from premises, in his phrase, and as the determination of certain generalities. So this is Summa Theologica Prima Secundae, question 95, article 2, and I quote, "The first is like to that by which in the sciences demonstrated conclusions are drawn from the principles, while the second mode is likened to that whereby in the arts general forms are particularized as to details. Thus, the craftsman needs to determine the general form of a house to some particular shape. Some things are therefore derived from the general principles of the natural law by way of conclusions. For example, that one must not kill may be derived from the principle that one should do harm to no man, while some are derived therefrom by way of determination. For example, the law of nature has it that the evil doer should be punished, but that he be punished in this or that way is a determination of the law of nature." End of quotation. This means that certain human laws can be derived in a fairly simple way, what Aquinas calls conclusions from the natural law. The natural law forbids the killing of the innocent. Human law should do the same. The other way of getting human law out of natural law by determination is not so simple. The example given in the passage just quoted is about specifying the punishment of an evildoer. The implication is that this can't be inferred logically from the natural law because there is no single right way to do what natural law requires. It doesn't follow that all possible forms of punishment are equally good, but it does seem reasonable to think of a range of possibilities as being perfectly acceptable. Aquinas does not go into great detail about human law, but we can develop these basic principles and come up with a number of groups of cases in which a human legislator might have good reason, for the benefit of human life, as Aquinas expressed it, to pass laws which related to the natural law in the second, vaguer way. The most obvious category of things which may be needed to be set by law concerns those things which must be done but can be done in more than one way. Aristotle, quoted by Aquinas, observes that different cities have different rules about certain standard sacrifices and the sum of money to be paid for a ransom. Presumably he's referring to prisoners of war. There are many cases in which it is good to fix how something should be done for the sake of clarity, ease of enforcement, and so on, but where a range of ways of fixing it would be perfectly reasonable. It is because there is no single right way of doing certain things that the natural law cannot specify. The natural law has concrete implications for each situation, but leaves some matters undetermined. For example, we might contemplate the natural law obligation to honour our parents in the context of our particular circumstances and decide that we need to ensure that the old folk have somewhere to live. But we could contemplate the natural law all day long without it revealing to us exactly where that should be, or choosing for us between two equally convenient, commodious, and economical possibilities. Immanuel Kant called this an imperfect duty, a duty which can be fulfilled in more than one way. One important group of cases is, to use modern terminology, that of coordination problems. The purest example is the problem of which side of the road to drive on. It makes no difference whether it is the left or the right, but as a community we have to have a rule, and once established we had better stick to it. It is a feature of coordination problems that once it is decided, everyone who is rational will want to do what everyone else is doing. There are many other cases where coordination is at least part of the issue. For example, it makes for greater efficiency if everyone knows where to go to get a passport or a driving license. Constantly changing the names and locations of the agencies doing these things would create unnecessary costs for everyone, even though there is nothing about their current names or locations which has been set by natural law. In the case of driving on the left or right, the natural law indicates that there is a value to human life, and therefore, we may conclude, to road safety, and it follows from this that there is a value to fixing which side of the road we should drive on. This creates the opportunity, and perhaps the obligation, for the state to determine it one way or the other, or again, it may be fixed by custom, which is itself a form of human law. This law has got very little to do with repressing vice, but promotes the common good in a completely different way. It does imply, of course, that the state has the power to impose a new obligation to do the thing which it decides should be done. A different way in which human law can relate to natural law is by asking more of people than the natural law does. Aquinas talks about the Mosaic law holding the ancient Hebrews to higher standards, and the evangelical counsels, poverty, chastity, and obedience, recommended by our Lord in the Gospels, which hold religious to a higher standard than everyone else. In both cases, one reason for doing this is a matter of the common good. The ancient Hebrews needed to be sanctified to make them a suitable community for the Messiah to be born into. The Christian community benefits from the existence of vowed religious in a kind of division of labour. Aquinas talks about this in another work of his, Summa contra Gentiles, Book 3, Section 2, Chapter 134. However, it can also be better for the people who end up living by the more demanding rules. Aquinas observes that the Hebrews attained what he called a better state than other nations, and Gentiles who took on these obligations before the proclamation of the gospel, that is to say, the pagan proselytes that St. Paul met on his travels, like the Christian religious later in history, had an advantage in gaining salvation. Aquinas talks about this in the Summa Theologica Prima Secundae, question 98, article 4. As discussed in previous presentations, a conception of morality based on rules allows for good action which goes beyond the rules. The rules in Aquinas' understanding fix the minimum required for salvation. It therefore makes perfect sense for some to go beyond them in a systematic way in order to make their salvation more secure and also to earn extra merit. As the example of the ancient Hebrews shows, this can be applied to a whole society. It is therefore possible for the state, with due prudence about asking too much of people, to ask a little more of them than is required by the natural law. Having just given the example of religious vows, it is worth noting that these invite the question, in parallel with the question I have asked of human law, of why anyone would want to impose an obligation on himself which went beyond what was required by natural law. Part of the answer has already been given. Because the way of life which has been vowed has some usefulness to the community, and because that way of life makes salvation more secure for the person living it and earns merit. Modern critics may ask, nevertheless, why this way of life has to be a matter of an artificial obligation created by a vow. Why not just do it, as non-vowed Christians do when they take on some spiritual exercise for Lent, or indeed for life? Aquinas defends the practice of making religious vows in the Summa Contra Gentiles against the charge that it makes the vowed action less meritorious as being compelled. This is in Book 3, Section 2, Chapter 138. He draws a parallel between a vow and a habit in intensifying our inclination towards an act. In addition, he says that since fulfilling a vow is good, this adds to the goodness of doing the action in itself. In this way, we do two good actions at the same time: the vowed action, which is itself good, and fulfilling the vow. In the same way, if the state or the church or a superior of any kind makes a good action obligatory for us, doing it adds obedience to the goodness the action has in itself. He comes back to this question in the Summa Theologica, Secunda Secundae, question 88, article 6. In the case of vows, since the vow is made to God, fulfilling a vow is an example of the virtue of religion. This is Summa Contra Gentiles 138, which is directed towards God himself, unlike an act of continence or abstinence performed without being vowed. Vowing an action, therefore, is a way of offering it up, as the saying is, and offering not just the action, but something more. Supposing a man does something for God's sake, offering this act to God, if he does this under a vow, he offers God not only the act, but also his power, since in vowing it, he prevents himself from doing anything else. In summary, a vow intensifies our inclination to act and is a way of directing our intention towards God. The role of human law in dealing with the indeterminacy of right action has special importance because it pulls away from the idea suggested in Plato and again in the work of modern political theorists like Jean-Jacques Rousseau, that the ideal state would only ever ask us to do what we would do anyway if we were perfectly rational. In the untidy world of the Middle Ages, in which very different customs were to be found not just in adjacent countries, but in adjacent villages, and in the context of the revolution of divine precepts caused by the coming of the Messiah, Aquinas recognized that the human law does not exist only to tell us what we ought to know already. It exists to solve practical problems, to make necessarily arbitrary decisions, and to make us better people than we would otherwise be. Human law derives its obliging force from natural law, but, at least for most of its content, not in a simple way. Human kings and judges have real authority, not as mouthpieces for an ideal abstract law found in the hearts of every rational person, but as governors of complex human communities. It is worth underlining the implications of the natural law tradition for the inevitable variation between different communities in their laws and ways of life. Except insofar as these variations can be explained in terms of the different conditions in which they exist, differences of climate, for example, these differences are seen by Plato and the Stoics as evidence of imperfection, as deviations from the ideal. Aristotle is much more relaxed about them and is also more aware of the complexities of social and political life, which make some constitutional arrangements more suitable to some communities than to others. Aquinas and his followers, however, go further than this. The natural law does not offer us a detailed blueprint for political and social life. It makes some basic demands, but has to be implemented, and it can be implemented in a range of ways. These are not all equally good, but there is a range of perfectly reasonable ways of doing things, and it may be better to maintain even suboptimal arrangements when they have become established, given the high cost of changing them. The different ways of making provision for the basic requirements of a political community, defense, commerce, agriculture, and so on, imply subtle differences in the way different values are ordered, interpreted, and related to each other. These can be reasonable and yet distinct. There was a variety of political arrangements in Aquinas' day. There were unitary states under monarchs, like England. There were aristocratic city republics in Italy. There were kingdoms joined by conquest or marriage, but not unified in their laws and customs, as was happening between England and Wales and in Spain. There were states presided over by the popes and by the Teutonic and Maltese knights. And there was the complex institution of the Holy Roman Empire. All of these kinds of states had democratic, aristocratic, and monarchic constitutional elements. Aquinas notoriously hardly mentions the empire. It may have been a topic he preferred not to broach for political reasons. But the complexity and variety of institutions and ways of life, like the liturgical variety of the Middle Ages, is something that can be accepted as expressing each community's contribution to an understanding of the fundamental principles of the natural law, which can never be complete. It represents diversa non adversa, as they said. Among this complexity is something I have not yet mentioned, how the Middle Ages displayed in a special way what is true to some extent in all societies, which is the dispersal of authority among many institutions. The most obvious of these is the power of the church over and against the state, but it is important to set the relationship between church and state in the context of the collaboration and rivalry between the state and a whole host of other institutions. In the medieval Europe of, say, the 13th to 14th centuries, there was not just one kind of law or one institution, the state, which one had to obey. The state's courts, or the crown courts, were supplemented by feudal courts presided over by barons, prince-bishops, and those they appointed, by the internal procedures of trade guilds, the inns of courts, and the universities, and by ecclesiastical courts. All of these institutions have their own sets of laws, their own procedures, and their own customs. One might dismiss these other sources of law as something similar to a disciplinary tribunal set up by a firm to deal with complaints made by one employee against another. But these were of a much greater significance. Feudal courts had a range of corporal punishments available to them. If a guild chose to eject a member, that person might well find it impossible to ply his trade in his city ever again. The University of Oxford, I like to remind my students, had the right to invoke the death penalty and had its own gallows for this purpose the gownsmen's gallows, which can be seen on historical maps of Oxford. Church courts could find people guilty of crimes worthy of death and hand criminals over to the state for the sentence to be carried out. In many cases, the authority exercised by these bodies was ceded to it by the Crown, which would grant them rights and privileges when they were established, or subsequently, for example, when they gave town charters. In other cases, however, they gained these powers from custom. Universities were given the right to grant degrees by the Pope. Feudal lords and ecclesiastics could also use their authority to give rights to other individuals and institutions. These different institutions, however, were not competing head to head because they did not all have the same purpose. Trade guilds existed primarily for the sake of their members in their professional capacities, and the Inns of Court and the universities were similar institutions for lawyers and academics. They regulated the activities of their members in a particular respect, whether it be the selling of fish in London or the teaching of metaphysics in Oxford, and defended their members from other institutions and from the Crown. The Church and the state encompassed almost everyone in a country, and the same person might in addition be a member of several other such institutions, a town corporation, a trade guild, and one or more devotional guilds. Just as your life as a silversmith could be regulated by one guild, and your devotion to the Blessed Sacrament find its expression in another, so your worldly concerns were ultimately the concern of the state, and your supernatural destiny that of the Church. That is not to say that there was a strict compartmentalization of purposes. Trade guilds would concern themselves with their members' eternal souls and arrange funerals and ongoing prayers for the dead. Parishes were responsible for the material support of their poor members. Monasteries might be given the task of maintaining a road or a bridge, and the bishops, as a group, might give a subsidy to the Crown to help pay for a war. Although there was in practice a fair amount of conflict between these institutions, there was also a good deal of cooperation. In this context, it is not surprising to find Aquinas saying that the state has the task of ordering temporal affairs, concerning itself with its subjects' natural end, and the Church with supernatural affairs and man's supernatural end primarily. There is no question of a separation of church and state in the modern sense, but simply of a division of labour. As noted above, some of the institutions of medieval society came into existence by custom, and others by being recognised and given rights and powers by other institutions and sources of authority. The church, the state, and the family, however, come into a different category. There was a debate in the Middle Ages as to how the state came into existence. On one view, it was established by the consent of people who wished to band together to defend themselves, a view which was popular among later political theorists, including Thomas Hobbes. As already discussed, however, Aquinas took the view that a political authority was exercised in the first family by the first father of a family, Adam. The state, on this view, might be seen as a spin-off of the family. The Church's origin is much easier to ascertain. It was established by Christ on the Apostles. The Church's nature and authority come from God, as the divine law comes from God, as something added to the set of institutions and rights and obligations which exist by natural law. The family, on the other hand, is a fundamental institution of natural law. Its existence reflects human needs. As Aquinas observes, small children are helpless and need the support and protection of their parents, not only in relation to their bodily needs, but also in terms of their intellectual formation. I quote from the Summa Contra Gentiles: "Man lives by reason, which can attain to prudence only after long experience, so that children need to be instructed by their parents, who are experienced." Unquote. This implies an enduring union between parents. This is from the Summa Theologica. Now, it is evident that the upbringing of a human child requires not only the mother's care for his nourishment, but much more the care of his father as guide and guardian, and under whom he progresses in goods both internal and external. Hence, human nature rebels against an indeterminate union of the sexes and demands that a man should be united to a determinate woman and should abide with her a long time or even for a whole lifetime. Hence it is that in the human race, the male has a natural solicitude for the certainty of offspring, because on him devolves the upbringing of the child, and this certainly would cease if the union of sexes were indeterminate. This union with a certain definite woman is called matrimony, which, for the above reason, is said to belong to the natural law." Unquote. The institution of the family thus serves as a model of how Aquinas understands natural law, not just as a set of dispositions, but as a complex moral framework. Since it is clear that the human race would not survive without procreation, it is obvious, Aquinas tells us, that sexual union is not sinful in itself. That's in the Summa Theologica, Secunda Secundae, question 153, article 1.2. Since the upbringing of children requires stability over long periods of time and the commitment of the father as well as the mother, it follows that sexual union should take place only within the context of marriage, and that marriage should be permanent. Marriage itself, as the context for sex, since it gives the parties rights over the other's body, can only be established by the consent of the two parties. Aquinas, or the supplement to the Summa put together from his earlier writings by his students, accordingly calls consent the efficient cause of matrimony. This is the supplement 45, section 1. Finally, by an act of divine law, marriage was elevated to the status of a sacrament. This perfects natural marriage by making it perfectly indissoluble and by giving spouses special graces to enable them to carry out their calling of the common life and the upbringing of children. One may say then that marriage and the rules governing it grow out of its purpose, its teleology. In this lecture, I have shown how, according to Aquinas, human legislators and human custom can derive from natural law and also add to it in certain respects. Fundamental to Aquinas' conception of human law is the idea that natural law does not settle everything, and nor can things be settled simply by rational reflection about abstract problems. Even a society of ideally rational people would not all come to the same conclusion about where a bridge should be built or which side of the road to drive on. Human governors and legislators and custom are needed to guide human communities and to make what can sometimes be necessary but arbitrary decisions. The context in which Aquinas thought about human law, however, was importantly different from the modern one. In his day, there were many sources of enforceable obligations on people, including the church as well as the state, public vows, and a variety of institutions such as religious orders, guilds, universities, and intercourt, as well as a web of feudal obligations enforced by feudal courts. The origin of these institutions are various, but while the church was established by Christ when he was on earth, the family is a fundamental component of human society, which goes back to our first creation and is antecedent to the state.
Thank you. Thank you, Dr. Shaw. And well, we have some questions. The first one is about wokeness. It's because the hypocrisy of woke values of equality and toleration is so evident, wouldn't it be fair to say that it's simply about fostering vice and suppressing virtue rather than the other way round?
Well, I don't think that's the way that they would express it. I mean, they think that that the things that we regard as virtuous are vicious and vice versa. I mean, quite literally in some cases. So you know, continence within, for example, I mean, it's just a form of mental maladjustment. So they have an ideal. I'm not very well thought through necessarily, but they do have an ideal of what human nature should be like, and they are pushing towards that as much as they can. The problem is that their ideal is deranged too. Yeah.
Thank you. So, another question then. Could you briefly clarify the difference in meaning between the Church's toleration of heretics and pagans, for example, and the doctrine of religious liberty, which it condemns? Is it that the Church's teaching is not a question of rights, but of the common good?
Well, we'd have to test exactly what the religious liberty condemned by the Church meant, and I haven't covered this, but it is very briefly religious liberty as condemned by many popes, such as Pius X, Leo XIII, was an official view that all religions are equal. So they call this religious indifferentism. So it doesn't make any difference what religion you're in. You can go to heaven if indeed there is one, according to any of them, all equally true or untrue, all equally to be favoured or indeed disfavoured by the state. So the state should be neutral between them and not favour one over another. So and indeed not suppress any. So on this is the doctrine. This is the basis of people in America saying, well, look, I'm a Satanist and I claim my religious exemptions under tax laws, for example, and I demand that Satanist chaplains be provided for the American Armed Forces, and so on. So, and they don't have any argument against that because they've given up the idea that the state can take a view about religion. Whereas what the popes said was that don't be ridiculous. Of course, we take a view. You know, the office of the state who are baptized Christians, the state itself, which is under the authority of God itself. Of course, we can see the difference between a true religion and a false one, and that's one issue. And another issue is, okay, supposing there are people who have got things wrong about religion to a greater or lesser extent. Our response to them may well be to leave them alone. In some cases, it will certainly be to leave them alone. In other cases, then there may be problems. So the church, for example, in the end of the Roman Empire, they banned animal sacrifices made to pagan gods. That's something which probably most modern people would be quite happy to do, albeit for different reasons, perhaps. So they didn't hunt down and burn pagans at the stake. That would have been completely impractical. But they prevented the public celebration of pagan rites. So that's one thing you might do, which is partly tolerant, partly intolerant, and that's something which is quite characteristic of Catholic states. That historically, that they prohibit public expressions of untrue religions, but permit their private practice. They don't try to find out what you believe, and just leave you alone. Unlike the way that Catholics were treated in Protestant countries, where there were actually things like test acts and stuff, testing whether you would affirm this, that, or the other proposition, and if you didn't, then you'd be in trouble. So toleration recognizes that one thing is true and another thing is false. but for a range of reasons, I mean, most obviously purely practical reasons, it doesn't try to forbid everything which is false. But that's not because we don't know which is which. It's because of other reasons.
Thank you. So our next questioner asks this. So did Saint Isidore think that everything that is immoral should also be illegal, while Saint Augustine and Saint Thomas disagreed with this? And secondary question, same questioner has anyone else contributed to this discussion?
Well, lots of people contribute to discuss, and I wouldn't, I couldn't begin to list all the. I mean, political theory is a very lively debate in the Middle Ages, as it was before and after, and it's a very interesting area. And there are some people who are more Augustinian, and Aquinas is developing a distinctive view, which is then developed further by people like Ptolemy of Lucca, who was one of his disciples. I can't go into all of them, but St. Isidore of Seville, the point of my quoting him is simply that he was an Augustinian. So no, he wouldn't have gone beyond Augustine in demanding that the state suppress all vices. I quoted his definition of the law, the purpose of the law, as being for the suppression of vice, which is very Augustinian. But obviously Augustine doesn't think that could or should try to suppress every single vice, because that's just impossible, and indeed in some cases may well be counterproductive. So I think Isidore will be perfectly happy with that. Aquinas's contribution is to say, well, there's actually the state has positive things to do as well as the more negative suppression of vice, which isn't to say that the state only started doing those things with Aquinas, because in fact these sorts of things like building bridges and stuff, the Romans were very keen on that kind of thing, building aqueducts and roads and public goods and things. It's just Augustine didn't really think about that when he was deciding about the state. I mean, it didn't really occur to him that the promotion of the common good and the development of was something which the state did. He just wasn't thinking about that kind of thing. He was thinking primarily of crime.
Okay, well, I think we've got time for one more question. I'm going to choose a sensational one that somebody sent in. Were people really hanged under the supreme authority of Oxford University? Why did it have this authority?
Well, it would have been granted the authority by the Crown. As the university racked up all kinds of privileges in the course of the Middle Ages, as many other institutions did. Institutions which are useful to the state, to the Crown, and which could do the Crown favours. They would say, oh, by the way, could you grant us this privilege or that privilege or the other privilege? So, towns would be given the right to hold fairs without taxes being imposed on them. Oxford University in Cambridge, they got all kinds of things. So, policemen can pursue undergraduates into the college. On the other hand, the university had the right to hang its members. And yeah, it did do it. And the reason for this is I think quite instructive, which is that there were huge conflicts periodically between the town, the non-university Oxford, and the university members. So there was a terrible occasion, Scholastica's massacre. You can all Google that if you want to, when several people were killed in rioting and things. And colleges had walls around them, not just for fun, but to stop people just invading them and attacking their students. So these medieval institutions characteristically defended their members. That's what, because the state was weak. you can't expect the state to defend you in every situation against other powerful, because the state's not that strong. It doesn't have such a long arm as the modern state does. So in order to exist in a kind of happy way, you join yourself to institutions. You find a lord to be a servant to be a tenant farmer to, and that lord, in exchange for your service, will protect you. Or you find yourself a city guild of tradesmen, and they will protect you. And or you become a scholar, and you are protected by the university. And the quid pro quo is that if you misbehave, they've got to be able to deal with you before the outside powers drag you out and deal with you in their own way. And this, of course, is also true of the church. And this is one of the key things in the conflict between church and state. It's not an ideological conflict. It's about, was the church being sufficiently vigorous in prosecuting criminal clergy, or was it treating them too lightly? Because the church had the privilege of protecting the clergy, but also, of course, having tribunals, courts to punish them. In the case of the university, I don't know how often this happened. It did happen, and I remember being told that one particular college, I think it may have been St. John's, actually owned the gallows, and they got a fee every time it was used, which was quite nice. And this went on, I think I was told, into the 19th century. And I hope that's true, because it's just so splendid that they were hanging undergraduates. But the point is, actually, it's not a kind of terrible kind of totalitarian thing. It's for the protection of the institution's members. You can say to the outsiders, look, if there's a problem, we will deal with it. And look, this is us dealing with it. Actually, we're going to hang this guy. Otherwise, the whole institution will come into attack.
Well, thank you very much indeed, Dr. Shaw. I'm afraid that's all we have time for question-wise now, and apologies to one or two people whose questions have not been answered. We maybe try to get to them on at the end of another lesson. But thank you, Dr. Shaw. Thank you for everyone for taking part today. The video of this lesson will be made available on the Family and Life Academy website, along with study notes and other resources. And we look forward to seeing you for lesson 5 of the natural law course, which is entitled Enlightenment Ethics. And do please look out for our other current and forthcoming Academy courses. Au revoir, Dr. Shaw, and we look forward to seeing all of you again next time.